Hello, everyone, and welcome back to the IP Edge, the podcast where we decode big legal questions in plain English. Today, we're jumping into something that's been shaking up the creative and legal world. Can an AI generated artwork really get copyright protection, especially under the New Zealand law? Well, I am aware that you might have heard about the 2023 Zarya case for handles work created not by humans but by machines. Just grab a coffee, settle in, and let's explore where the law meets the algorithm. Before we jump in, a quick note for my listeners. This episode is going to be a little different. I'm going to leave a few open-ended questions throughout the discussion, the kind that don't have clear answers yet. So think of this one as the start of an ongoing conversation between you, me, and the law. Let's start with the story. In 2022, a US artist named Chris Castanova released a comic book titled Zarya of the Dawn. It had vivid, almost cinematic artwork, the kind you might expect from a professional illustrator, but here's the twist. The images were generated using an AI tool called Midjourney. The US Copyright Office initially granted it, but then revoked it in 2023 once they discovered that the visuals were AI generated. The office reasoned, while the text and story arrangements show human creativity, the images made by Midjourney don't qualify because they lack human authorship. In short, machines can't be authors, at least not in the United States. Now here's the question that makes lawyers and creators sit up. What if the same comic had been made here in Aotearoa, New Zealand? Would it be protected under our copyright law? New Zealand's Copyright Act gives us a fascinating twist. The author shall be taken to be the person by whom the arrangements necessary for the creation of the works are undertaken. That means, even if a piece of art or music is made by AI, the human who planned or set up the creative process can still be recognized as the author. So if Chris had produced Zarya of the Dawn in New Zealand, she could potentially argue, I made the arrangements, I wrote the prompts, curated the outputs, selected the final images, therefore I'm the author. Under New Zealand law, the arguments actually carries weight, but here's the key. Originality still matters. Our courts have consistently held that to qualify for copyright, a work must involve some degree of skill, labor, and judgment. Cases like Bleeman versus News Media and Land Transport Safety Authority versus Clogo shows that the threshold for the originality is low, but it must exist. So, as long as Chris could demonstrate genuine creative input, for instance, choosing the prompts, editing outputs, and curating the sequence, she could probably clear that threshold. Do you think typing detailed prompts into an AI tool count as creative skills? Like pressing a button and letting the computer do the heavy lifting? Take a moment to think. Let's break this down even further. The law still views originality through a human lens, but AI tools like Midjourney complicate that because they blur the line between author and instrument. Imagine two scenarios. In the first, a designer sketches every detail by hand, classic human authorship. In the second, the same designer uses Midjourney, refining prompts over hours to get the right tone and lighting. Who's the true creator? The algorithm that generated the pixel? Or the human who guided every step? Under the New Zealand Copyright Act, the second person, the prompt writer, would likely be deemed the author because they made the arrangements. Yet, the copyright subsistence still hinges on originality. If the human contribution is minimal or purely mechanical, protection might fail. This is where the Zarya case gives us a warning. Courts might accept that AI is a tool, like a paintbrush, but not the painter itself. Think about when you use Canva or ChatGPT. If you tweak, modify, and add personal input, it feels like your creation, right? But if you just click generate and publish the result, does it feel like yours? New Zealand is actually one of the few countries that already recognize computer-generated works. That's progressive, but it also leaves some gray areas. For example, what if multiple people collaborate with an AI? Who's the arranger? How do we measure originality when the output is unpredictable? And should AI-generated works enjoy the same duration of copyright 50 years after the author's death when the author might be a company? Our law hasn't answered these yet. That's why legal scholars, including in my own research, argue that it's time to clarify what originality means when AI is involved. If you were a digital artist, would you feel motivated to experiment with AI if you weren't sure your work could be protected? That's the delicate balance lawmakers need to strike between encouraging innovations and upholding fairness. So let's tie it all together. Zarya of the Dawn showed that the US draws a hard line: no human authorship, no copyright. But here in New Zealand, our Copyright Act leaves the door open, recognizing the person who makes the arrangement as the author even for computer generated works. That means, at least for now, AI art can be protected here, provided there's a traceable human hand behind it. Still, the story is far from over. As AI models becoming more autonomous, we'll need to revisit our definitions of originality, clarify ownership, and perhaps rethink copyright from the ground up. Next time you see an AI generated painting or song, ask yourself, is this creativity, computation, or a little bit of both? Thanks for tuning in to the IP Edge. If you enjoyed this episode, follow and share it with someone who loves tech, art, or a good legal debate. I'm Abhishek. Until next time, keep questioning, keep creating, and remember, the future of creativity is not man or machine, it's man and machine.